Good morning. My name's Stephen King. I'm a consultant with the firm Mills and Reeve, and my subject area is healthcare risks, including malpractice or clinical negligence. Joining me today is Principal Associate Jagjit Virdi, who works with me on the more catastrophic malpractice cases. This session is being recorded and will be available afterwards. You can ask us questions using the Q&A facility, which if we have time, we'll tackle at the end, or when circulating the notes. You can also contact us directly with any follow-up questions. Today, we're going to cover 3 cases that have arisen in the past year. The first looks at material contribution. The second, appropriately, looks at secondary victims. And the final case looks at the liability of experts for errors in their reports. So the first case, Thorley. The background to this case was that of a patient with a condition that carried an increased risk of blood clots and strokes. He was booked in for an angiogram, which carried a risk of bleeding, and consequently he was advised to stop his regular anticoagulant medication for 6 days before the procedure. He suffered a stroke 3 days after the procedure, resulting in permanent impairment, cognitive and physical. The claim against the trust was that his anticoagulant should only have been stopped for 3 days. But on the issue of breach of duty, the court went with the defense experts and the arguments following cases such as Bolam and Belifo that a 6-day stoppage wasn't negligent. The more interesting point, which the court dealt with fully, was causation. What would have happened had the medication been stopped later or started again sooner? Firstly, can the but-for test be answered favorably for the claimant on the balance of probability? This was the outcome in the case of Davies and Frimley Health NHS Foundation Trust, where but for the delay in administering antibiotics, the patient wouldn't have died of bacterial meningitis. In Thorley, the judge dismissed the but-for test and went on to consider if the case was one where that test can be modified on account of material contribution. That modified test, applying material contribution, can only be used in limited circumstances, certainly at the moment anyway. A good example of where this modified test was applied was the case of Bailey and the Ministry of Defence. Here, the claimant aspirated vomit, causing a cardiac arrest, causing brain damage. The question was whether the weakened state of the patient was caused by negligent care and/or pancreatitis, and if both, were they cumulative? The judge was unable to say that absent the negligent care, the cardiac arrest wouldn't have occurred, but was able to say that both the negligent care and the pancreatitis made a material contribution to the patient's weakened state, and causation was established. So did the modified test apply here? The claimant cited the Williams case, where successive events in care led to complications from a ruptured appendix. Here, the court said that the sequence of events may be highly relevant in considering whether a later event made a material contribution to the outcome. But here we also see reference being made to there being an indivisible injury. The claimant's case was that the divisibility or indivisibility of the injury was relevant only to the measure of damages against a contributing tortfeasor, not to the principle of applying the modified test of causation. So in Thorley, we have a stroke, which either happens or does not. So it's an indivisible injury. The severity of the stroke wasn't linked to the dose of anticoagulant. In contrast to the Williams case, the defense relied on the indivisibility of the injury being a bar to causation based on material contribution. They relied on the Court of Appeal case of Ministry of Defence and AB, a 2010 case, which was about exposures to radiation. And whilst that case went to the Supreme Court, the judgment didn't deal with causation in any detail and said nothing to undermine the reasoning of the Court of Appeal. So the judge held that where there is an indivisible injury, as there was here, there's a bar to relying on arguments around material contribution. In any event, and separately, if the judge was wrong on that, he rejected the argument of material contribution on the basis of the claimant's own expert testimony. That referred to a material contribution to the risk of an injury rather than the material contribution to the injury. The judge noting, as on the slide, the difference between risk of injury and material contribution to actual injury. And that comes from the case of Hennigan and Manchester Dry Docks. So what are the takeaways? Well, probably the main one is that the judge in Thorley commented that the whole subject of material contribution, and especially where you have a single tortfeasor and an indivisible injury, is a legal issue ripe for authoritative review. So we can expect more on this. Even though there are prerequisites for applying the so-called modified causation test, there is confusion about whether the divisibility of an outcome is relevant or not, and especially in a clinical context. There's a very interesting discussion article from James Arney QC, available online, which suggests that the Thorley decision, insofar as its authority, any authority on the subject of material contribution, should be treated with caution. Thank you. I'll hand you over to Jagjit Virdi and the topic of secondary victims.
Thank you, Stephen. Good morning, everyone. I'm going to talk about the recent Court of Appeal decision from January 2022 concerning 3 combined cases that look at the issue of liability for psychiatric harm and secondary victims in cases concerning clinical negligence. Those cases being Paul against Royal Wolverhampton NHS Trust, Palmer against Royal Cornwall Hospital NHS Trust, and Purchase against Ahmed, all of which these 3 cases were considered in a combined manner by the Court of Appeal. The law around psychiatric harm and secondary victims is particularly complex, and it is no surprise that having handed down the Court of Appeal judgment, these key cases are now subjects of appeals to the Supreme Court. We expect the Supreme Court to provide clarification of the law relating to secondary victim claims, but until the Supreme Court considers this issue further, it is necessary to consider these 3 cases mentioned and how the law currently stands. The facts of these cases were similar in that there had been an alleged failure to diagnose life-threatening condition, and after a period of delay, the victim then suffered a traumatic death. In the case of Paul, Mr. Paul was with his 2 young daughters on the 26th of January 2014, and he suffered a fatal heart attack where he subsequently fell and suffered a severe head injury. Unfortunately, his 2 young daughters witnessed this event and the subsequent scenes to revive him. The event was so shocking to the extent it had caused psychiatric harm to the daughters and to his wife, who later attended whilst paramedics were performing chest compressions. The alleged negligence omission was a failure to undertake a coronary angiogram in November 2012, so 14 months prior, which would have revealed the coronary disease that could have been treated to avoid the heart attack. In Palmer, Esme Palmer was aged 7 years when she felt unwell on a school trip on the 1st of July 2015. Her parents had agreed to bring her back, but when they reached her, they found her lying on the ground with staff members giving mouth-to-mouth resuscitation. She shortly died afterwards. The parents suffered from post-traumatic stress disorder from seeing Esme lying on the floor and seeing the attempts to resuscitate. It was later discovered that Esme was seen by her GP earlier on the 19th of August 2014 when she complained of a variety of strange episodes affecting her breathing. Various tests conducted by paediatricians then resulted in nothing particularly abnormal being found. However, these problems continued, and in April 2015, she was again referred to paediatricians with worsening symptoms, but unfortunately for Esme, she tragically died before a formal diagnosis of pulmonary veno-occlusive disease could have been made. Her death on the 1st of July, witnessed by the claimants who were the parents, was of course a shocking event, and the defendant admitted that the condition of Esme should have been diagnosed earlier by at least mid-January 2015. In the case of Purchase, Evelyn Purchase was aged 20 years of age when she died on the 7th of April 2013 from extensive bilateral pneumonia with pulmonary abscesses, which it is alleged should have been diagnosed at least 3 days earlier on the 4th of April 2013. Evelyn's mother, who was the claimant in that case, returned home later that day and found Evelyn lying motionless on the bed with a house telephone in her hand, staring at the ceiling and not moving. Understandably, the claimant developed post-traumatic stress disorder, severe chronic anxiety, and depression with continuing symptomology. So in the Paul and Palmier cases, the shocking death happened in the presence of close relatives, causing them psychiatric injury. In the case of Purchase, close relative happened upon the victim immediately after the death. So the question in each case was whether there was necessary legal proximity existing between the time between the defendant's negligence and the events that triggered the injury to the secondary victim. According to the analysis of the Court of Appeal, the issue of legal proximity turns on the relevance of the time intervals between the actual clinical negligence and the damage caused by it, and the shocking event that ultimately causes psychiatric injury to the claimant. In other words, the horrific event witnessed, which triggers psychiatric injury, must be contemporaneous with the act of negligence itself, unless it can be proven that the negligence and the horrific event were ongoing. The Court of Appeal, in the cases of Paul, Palmier, and Purchase, relied upon the decisions of the House of Lords in cases before, concerning in the case of Alcock and the Chief Constable of South Yorkshire Police, which is a 1992 decision, and the findings of the Court of Appeal in Taylor against A. Novo, which is a 2013 case. And in that particular case, it was held that if the shocking event occurred beyond the immediate aftermath of the defendant's negligence, then a secondary victim claim would fail. It's worth noting that in Alcock and in A. Novo, they were both accident cases as opposed to cases concerning clinical negligence. In fact, in Paul, Palmier, and Purchase, the Court of Appeal noted that the issues they had to decide had never specifically been considered before in the context of clinical negligence. In the slide before you, I have inserted a quote from the Master of the Rolls, Sir Geoffrey Boss, who gave the lead judgment. He expressed that there must be proximity between the negligence and the psychiatric harm suffered by the secondary victim. However, later in the judgment, he also suggests that a continuing omission may also offer sufficient legal proximity. Further in the judgment, the Court of Appeal also expressed reluctance in having come to the conclusions they had, going so far as to invite a reconsideration by the Supreme Court. Again, I've included a further extract where the Master of the Rolls expresses support of the secondary victim claims. However, based on previous cases, the Court of Appeal is bound by early decisions which require redress by the Court of Appeal. It will be interesting to see what the Court of Appeal, what the Supreme Court has to say on these particular issues, as they do require resolution. Lord Justice Underhill, in a supporting judgment in Paul, Palmier, and Purchase, highlighted the conflict with the law as it stands. In particular, if a doctor who negligently prescribes a medication kills the primary victim, he would be liable to the secondary victim if the patient took the medication and died in shocking circumstances immediately, but not if that event happened a few days or weeks later. As you can see, there is some conflict here as the law stands, and again, it does require a further consideration from the Supreme Court. So it will be interesting to see what actually happens. But for the moment, we have the law as it stands. I will now pass it back to Stephen King, who will discuss recent developments concerning the liability of experts. Thank you.
Thanks, Jag. This is the case of Radia and Marks earlier this year. Can an error of fact in an expert report give rise to an action in contract or tort? Both breach of contract and negligence requires a loss to have arisen within the scope of a contractual or tortious duty of care. So any loss falling outside that scope isn't actionable. The background to this claim for damages against Professor Marks was an earlier claim the same claimant had made against his employer in an industrial tribunal. The claimant worked for a global investment banking firm as a research analyst. He was diagnosed with acute myeloid leukemia, which required quite a lengthy admission to hospital for treatment and then a return to work on a phased basis. He commenced proceedings in the employment tribunal alleging disability discrimination against his now former employers. In the run-up to the hearing of that tribunal, the defendant was instructed jointly by the claimant and his employer to provide a report and comment on a number of matters. One of them was the weight of the claimant at the end of his chemotherapy treatment. The weight loss was a significant fact the claimant relied on to corroborate his case against his former employer that he suffered post-chemotherapy treatment fatigue. He said it was a disability, and it formed the basis of his disability discrimination claim against the employer. Before the tribunal, a contemporaneous treatment record was relied on by the employer, showing the claimant's post-treatment weight as 81.5 kilograms, which was quite different from the 50 kilograms that the defendant had reported. The tribunal found that the claimant's evidence, including that about his post-chemotherapy treatment weight, was unreliable. They dismissed the claim, and he was ordered to pay costs in excess of £600,000. In this case, he claimed damages against Professor Marks on the basis that the defendant had failed to review the records and identify this document and the discrepancy, and that this alleged breach of duty of care had caused the employment tribunal to find that the claimant had been dishonest. The defendant admitted his oversight in not spotting the weight information and the discrepancy, but he asserted that he was entitled to rely on the claimant's oral history when he met him. His clinic note confirmed what he'd been told by the claimant, that his weight had reduced to 50 kilos post-treatment. So the judge laid out 3 questions to consider as on the slide. On the first point, the judge agreed with Professor Marks and found that it wasn't within the scope of the expert's duty to protect the instructing party from the risk of an adverse credibility finding or a finding of dishonesty. On the second question, the judge also noted that whilst the defendant had made a mistake in not spotting the discrepancy about the weight, that mistake wasn't actionable, as he'd been provided with the records late, they were in a disorganized state, and he was then placed under significant pressure to produce his report. She also noted that no concerns were raised by the claimant about what had been said in the report until after the tribunal hearing. On the final point around causation, what would Professor Marks have done had he found the discrepancy in the records about the post-treatment weight? Well, his evidence was that he would have brought that fact to the attention of both the claimant and the former employer, as he was jointly instructed. He would have sought clarification. He would then have reported both what he'd been told by the claimant and what the records revealed. The claimant's case on causation was that had the professor spotted the inconsistency, the tribunal wouldn't have found the claimant to be dishonest. That case was unsurprisingly rejected, with the judge citing various reasons why the tribunal found the claimant to be dishonest, such as his involvement at times in what the tribunal had called blatantly illegal conduct as a financial professional when conducting a particular financial transaction, and his evasive and misleading responses and testimony in an effort to support his own case. So the takeaways from this are on the slide. We'll take questions later, but that's the end of the presentation. Thank you.
Well, I think, Stephen, we do have a couple of questions that have come in whilst you've been speaking. So if I might now pass those to you both to see what your views are. Can I take referring to the Radia decision first? I think we accept that the mantra is that the expert has an overriding duty to the court, and that if this is fulfilled, there can never be a breach of duty to a party instructing them. But the questioner asks, can there be? Do you accept that position unequivocally? because the outcome against the expert does appear to have been extremely harsh. Do you have a view on that?
Harsh to the claimant in sort of allowing the expert to get away with the error. No, I don't think that is harsh. And I do agree with the proposition that if an expert fulfills his obligations to the court, I don't think there can ever be a claim for a breach of duty towards one of the instructing parties that he's reported to. I think here there's quite a lot of information about this case that isn't on the slide. So this chap, the claimant, came across to the industrial tribunal as telling a lot of untruths, which the judge in the civil claim referred to as dishonesty quite openly. He'd sued his employer previously for victimization. He'd then been sanctioned and ultimately dismissed for gross misconduct, and he then sued them for unfair dismissal. All those cases were dismissed, and then this one. And not a surprise that he was ordered to pay lots of costs, because the allegations were incredibly speculative and really had no merit. So he was hit with a big cost order. All that became apparent before the judge in this case. So I think this particular claimant was on a hiding to nothing. And Professor Marks, I do have some sympathy. I mean, a good practice point is that one must make sure that you are properly instructing the experts. There's nothing said about the fact that this inconsistency in the records wasn't picked up at the time the expert was instructed. It should have been picked up perhaps by the solicitors who were instructing him, or by the claimant themselves, but it wasn't. And that may have been because everything was a bit jumbled up, as the judge referred to. But I think those kinds of issues, making sure the expert has the information in good order, can work his way through it, has their attention drawn to any inconsistencies, and has time to properly consider it. They're probably the takeaways in terms of practice.
Yeah. And I suppose this is a set of circumstances which is, in some respects, slightly unique, given the behavioural traits of the past. I wonder, Jack, could I pick up with you a question about secondary victim claims? Looking at what has been said about the law relating to these claims, it's understood that there isn't yet any judicial finding on the point. I mean, our legal system works on the precedent basis. But do you think that the outcome of the decisions that you looked at is an example of a flaw in the system? Do you think it's right that to succeed, the cause of the secondary victim's loss must be sufficiently proximate to that of the primary victim, there being no room for the causative event to have been separated in time? Is this a realistic ask for the secondary victim?
I think at the moment, Harriet, the law as it stands, I think the parties in accident cases as well as clinical negligence cases have been following Alcock and A Novo, which suggests that should be proximity. So the cases that the recent Court of Appeal case, I think for the first time has stumbled upon this issue, which has been overlooked for many, many years, which requires there to be close proximity. And whether this is a flaw, I can't say for certain, but because I believe the parties would have been following previous judgments, and many cases have perhaps been settled out of court, not wanting to push the issue so far as to the Court of Appeal. But now we find ourselves been to the Court of Appeal and now to Supreme Court. And you ask, is it a realistic ask? I think things change over time. When Alcock's original decision from 1992 was in a different time, different place, different beliefs, thoughts and opinions. And at that time, potential floodgates argument, it was thought there must be a close proximity between the traumatic event and secondary victims. We are now nearly 20 years following that judgment, and society's changed, opinions changed. So the law, I believe, does need to adapt to that. And there does appear to be a conflict, especially with clinical negligence, because you can easily see by the cases considered by the Court of Appeal, whereby there is some alleged negligence and the trauma that may have followed days, weeks later. Is it right? With me personally, I struggle to accept that there must be a close proximity, because we can easily foresee scenarios where there may be a fatal event following months, weeks after the negligence itself. So I do struggle with that, but I do believe it's going to be a difficult decision for the Supreme Court to make, because there are larger policy considerations at hand. The NHS, as we're aware, is under strain. We're now approaching a period of austerity. So if the Supreme Court were to, so to speak, open the floodgates and say, okay, you can have a wider period of time, will that open up the floodgates for further claims? Potentially. So it's quite a tricky issue for the Supreme Court to consider.
So you would not subscribe to the view that perhaps this is a situation where there should be legislation to intervene and extend the ambit of the proximate cause, perhaps not least because of the potential for the floodgate situation to open up?
Yeah, I'm personally not for legislation, statutory legislation in that sense, because that will be extremely difficult to set out clear rules as to, right, what can you say is proximate? Is it on the day? Is it 2 days? Is it 3 days? And unfortunately, as we have seen in the past, statutory legislation does not necessarily solve all answers, give clarity. That can always be open to interpretation. So I think what is required is careful consideration by the Supreme Court, bearing in the facts, and distinguish between accident and those cases of clinical negligence. So it is a fine balancing act. It's not an easy answer to arrive to. And I wait with interest as to what the Supreme Court have to say.
Yeah. Well, thank you both very much indeed. Unfortunately, despite other questions, we are now running out of time. And so in our keeping to make sure we don't overdo it, I'll pass the baton back to you, Stephen, if I may, to close up.
Yeah, thanks. And we can get back to people directly on any outstanding questions. Our next session will be on Thursday, the 15th of December at 11 a.m, when my colleague Tom Philby will be discussing law reform on digital assets and asking the question, are insurers facing a new class of property and liability risks? So we hope you'll be able to join us on that occasion, as that will be the last cover talk for this year. We'll be starting up again in the new year, and details of the agenda for those sessions will be advertised in due course. But for today, this ends the session of Cover Talk. Thank you for joining us today, and we wish you a good rest of the day. Thank you. Goodbye.